Good afternoon. My name is Holly Smith, and I would like to welcome you to the Eversheds Sutherland Webcast, MiFID II, Overview and Main Impacts for U.S. Financial Institutions. I'm joined today by Eversheds Sutherland International Attorneys Andrew Henderson and Michaela Walker, who are in our London office, and U.S. Attorneys Meltem, Kodaman, and Ramirez, who are here with me in our Washington, D.C. office. A few housekeeping notes before we get started. If you would like to receive CLE credit for this webcast, please download the CLE sign-in sheet and evaluation form from your computers and follow the instructions for submission. If you have any questions during the webcast, please submit them via the Ask a Question text box. We do have a lot of material to cover today, so I'm not certain that we will get to all the questions, but I promise you that we will follow up individually with everyone who does ask a question. And if you would like to request a copy of the slide deck, please contact any of us who are speaking on this webinar today. We are going to cover key topics today based on our experience with MiFID II implementation for U.S. clients, including a MiFID overview, the extension of investor protection duties to U.S. delegates, investment research, and implications for U.S. derivatives end users that trade with EU counterparties. With that, I'm going to turn it over to Michaela in our London office to provide a brief overview of MiFID II. Michaela?
Yeah, thanks very much, Holly, and good afternoon, everybody from London. My name is Michaela Walker. I'm a partner in the financial services team here at Eversheds Sutherland in London, and I've been spending a lot of my time over the last 15 to 18 months in advising clients on the implications of MiFID II. Just before I start, I did just want to say that we're all thinking about you after the horrible events in New York yesterday. Obviously, we've had similar things in London, and just to let you know, our thoughts are with you on that. So, before we get into the detail of the implications, we thought it would be useful to give a very high-level overview of what MiFID is and what it's trying to achieve. And at its very basic, what MiFID II does is it repeals and replaces the current Markets in Financial Instruments Directive, MiFID I, which coincidentally came into force exactly 10 years ago today, just before the financial crisis. And the way that the directive is constructed is firstly by a directive itself, which has no application in member states in the EU. Each member state has to take the directive and apply it into its own law through legislative measures. There's a second piece to MiFID II, which is an EU regulation, and that regulation does have direct application in each of the member states. So member states have no discretion to change what's in that regulation. It will just apply automatically. As with most things European, there are further and additional measures which are in place and have been coming into place over the last 12 months at level 2 and level 3, and they tend to take the form of frequently asked questions or guidance, or in some cases further detailed rules, and they prove very useful in trying to interpret the high-level directive and regulation. MiFID II has a very broad application across the industry in Europe. It covers investment banks, broker-dealers, investment managers, investment advisors, exchanges, markets, and some data providers. However, it doesn't apply to managers who manage alternative investment funds under the AIFMD directive, or managers who manage UCITS funds under the UCITS directive, with the exception of those firms who carry out MiFID portfolio management. And even for those firms, not all the MiFID II obligations apply. However, having said that, individual member states are free to apply MiFID II requirements to non-MiFID firms. via a concept known as gold plating. And we've seen different approaches to that across Europe. In the UK, we've seen some fairly heavy gold plating of the MiFID requirements. So, for example, our regulator, the Financial Conduct Authority, has applied some of the MiFID requirements to AFINs, alternative investment fund managers, and UCITS managers. So those managers who had thought initially they were going to be exempted from MiFID II have had to play catch up to then try and work out how MiFID should apply to them. The implementation of MiFID II has been delayed. It was originally due to come into force earlier this year on the 3rd of January, but because of the amount of change that is required to implement MiFID II, that got pushed back. So following Halloween yesterday, we have the very scary fact that we've only got 62 days left now before MiFID II comes into force in Europe on the 3rd of January 2018. Quite a number of those days are not working days, so we have a number of bank and public holidays in Europe, and of course lots of weekends. So there are now very few business and working days for managers and MiFID firms to implement. So in terms of the requirements, what does MiFID II do? It really crosses a wide range of different activities that firms carry out. And I don't propose to talk to all the bullet points on this slide, but maybe just pull out a couple of them. So MiFID II increases the investor protection regulation that surrounds firms and their clients. So, for example, it introduces enhanced information requirements for firms to give clients. So, for example, increased disclosure around costs and charges. There is a harder and tightening of the rules on inducements, and we're going to talk a lot today about research and how MiFID II has affected that. And there's also changes to the best execution regime. There are also some enhanced corporate governance requirements and also some increased powers for regulators in terms of product intervention powers and also registration and authorization powers. So it's very, very wide in scope. And I think firms are finding that they are impacted across almost all areas of their business, from the information technology that they use, the legal teams, compliance teams, front office, accounts. Everybody has been involved in the MiFID II projects. So with that high-level overview, Andrew, I think you're going to now move to look at some of the considerations for US advisors.
Michaela, thank you very much. My name is Andrew Henderson. I am a partner of Michaela's in our financial services team. The focus of my practice is regulatory advice, both to investment advisors and to broker-dealers. And we have been looking at the extraterritorial impact of MiFID II, particularly where we either have investment advisor clients in the US who are looking for advice on how they ought to be interacting with their MiFID II clients, and then also the MiFID II managers here in Europe who are delegating functions back to those in the US. Now, the first point to note, and this is important, is that MiFID II does not change the territorial scope of MiFID I. The focus is still very much on activities which are carried on through a branch in the EU. And this is an important feature of EU regulation generally, and one that can be contrasted with the position in the US, is that the focus is not on the nationality of the client. The concept, for example, in the US of US persons doesn't resonate in the EU, but rather the focus is on where the activities are carried on. And an important difference also between MiFID II and the Alternative Investment Fund Manager Directive, AIFMD, which has been a very important piece of law for many of our US clients, is that there's no MiFID activity of marketing. There are activities that are analogous with marketing, and things of the activity of reception and transmission of orders. But the activity of marketing is not one which MiFID captures, but rather one that is left to each of the individual member states. Before the AIFMD, much of the analysis around the marketing of hedge funds and private equity funds in particular was really examined in the context of MiFID. That fell away with AIFMD. But it is important to note that one goes back to focusing really on what each individual member state does. And that brings us on to the next point. Many have led others to believe that MiFID II does have extraterritorial application because of a power which MiFID II gives to member states to impose a branch requirement on third country firms. But the important point to note is that this is not obligatory, but rather optional. And the text refers to those third country firms, such as US advisors or broker-dealers, that provide services to clients who are classified as retail clients or elective professional clients. Now, the concept of client classification is a very important one under MiFID, and much of the degree of regulatory protection will hinge on that. The lawmakers, when looking at this branch requirement, have focused in on this. But it's important to note that, as I said, this is not obligatory, but rather optional. I mean, there's an argument that if an individual member state wanted to impose that requirement now, that they could. So it's wrong to say that for that reason, MiFID II does impose an extraterritorial requirement. What is important to note as well is that the MiFID regulation, which Michaela mentioned, MiFIR, does create a third country passport for non-EU firms that wish to provide services to per se professional clients or eligible counterparties. These are essentially the types of clients who are more sophisticated or institutional in nature. And the effect of this third country passport, firstly, would be to override any individual member state branch requirement. But in order for this third country passport to be granted, and what is unusual is that it is the European Securities and Markets Authority, or ESMA, which has the registration power, not the individual member state authorities, as is the case under, for example, the AIFMD. But what is required will be an equivalence determination. Now, many of you who have been following a lot of the discussion around Brexit will be familiar with the equivalence concept. And indeed, there are aspects under MiFID, particularly around the recognition of organized trading facilities, which I know Ray is going to talk about. But this equivalence concept is followed through with this recognition of a third country firm to be able to carry on passport rights. Now, all of these points, as I mentioned, will also be relevant to US branches in London in the event that we have a so-called hard Brexit and the European passport rights are lost. So the advice that we're giving on these aspects isn't just being given to those of our overseas clients that are located overseas, but indeed to those that are located in the UK, indeed including some of our UK clients. I just want to move on and say something about territorial scope and delegation, because again, we say that the rules on delegation have not changed. There is a technical change in that the delegation provisions are now put into a so-called Level 2 regulation. Now, these are one of the EU measures that Michaela referred to that really put more meat on the bones of the MiFID II directive and MiFIR. And specifically, Article 31 of the so-called organizational regulation talks about delegation in terms that are reminiscent of those under the AIFMD. The essence being that you may delegate a function away, provided you don't delegate the senior management responsibility, such that the EU entity be turned into a so-called letterbox. And also, and this is important, in such a way that you do not alter the relationship and the obligations of the EU investment firm and its clients. Now, this is important because a number of EU managers have sought to apply equivalent standards to their US delegates, relying on this. And yes, it is true to say, and the EU Commission, in its questions and answers on original MiFID, made it very clear that a delegation may not result in a delegation away of obligations. But the extent to which you have to impose letter by letter the MiFID obligations on a delegate is something that is contested. Article 32 of the organizational regulation deals with the delegation of portfolio management specifically. Again, in a similar way to the AIFMD, it refers to the need for a cooperation agreement, and certainly our working assumption would be that the cooperation agreement, which certainly here in the UK, our Financial Conduct Authority has with the SEC and the CFTC, would also be relied upon in the context of this MiFID II delegation. But it is important to stress that Article 32, like Article 31, does not talk about the need to export the obligations. Rather, the focus is on ensuring that nothing is done which would somehow undermine the ability of the EU manager to discharge its obligations. I mentioned the European Commission Q&A on outsourcing under MiFID I, and that made it very clear that there is no extraterritorial application of MiFID. And it's important in this respect to compare this to the remuneration guidelines under the AIFMD and more latterly the UCITS directive, which governs in essence EU mutual funds, which made it very clear that where an EU manager delegates management to an overseas delegate, including one in the US, it must impose the same standards with respect to remuneration, and that's been quite a hotly contested and debated point. There is no similar express requirement at the EU level. However, in the United Kingdom, the FCA made a statement as part of its guidance generally that it would expect some exporting of obligations. It then backed this up in a letter to the Alternative Investment Managers Association in response to a letter that they had sent, and we'd been party to their letter seeking clarification, where it talked about the need for an equivalent level of protection, and that's quite a broad term. But the lesson here, and certainly the advice that we're giving to our US and indeed some of our other non-EU clients, is the EU managers may demand compliance as a matter of contract. And this is a point that needs to be made. A lot is often said about what the law says or doesn't say. We make the point that very often it doesn't come down to a strict reading of the law, but rather on the risk tolerance of the EU manager and the duties which it will seek to impose as a matter of contract. And indeed, we do have clients who come back and say, is it right that an EU manager should be demanding this of us? To which our answer invariably is that there is an argument for them to do so, even if, as a matter of law, we don't think this is strictly required. But it is a point to note. And this brings us handily onto the whole question of investment research, because in the context of delegation, it has been the rules around investment research that have caused the most controversy. And in short, MiFID II changed the rules under MiFID I such that it is no longer permissible for an EU manager to pay a broker-dealer for research using a bundled or soft dollar arrangements. Instead, what the rules implementing MiFID II say is that the manager or the advisor has one of two options. Where they use their client's money, the payment must be made through a so-called research payment account, or RPA, or alternatively, the investment firm may pay hard out of its own resources. Now, the manner in which an RPA is operated is prescribed, and the requirements are strict. We're not going to go through all of the requirements, but two are important. The first is that there's a duty to agree upfront a research budget, and also a duty to assess the quality of research. You should only be paying for research that is worth paying for. It should be noted that it is still possible to pay for research using a commission-sharing arrangement, but the watchword is the ability to identify and account for the amounts of money that are attributable to research. Now, this created an issue, both an operational one, but also in the US, the issue that was created, I know that Holly will say a bit more about this, was a regulatory issue. The essence of that being that it would not be possible for managers to pay broker-dealers using hard dollars without some type of regulatory change. Now, it's very timely, particularly in light of this webinar, that last Thursday, both the European Commission, which is the central lawmaking body of the European Union, so not actually a regulatory authority, but rather the body that issues laws, put out so-called frequently asked questions, that this is the way that the Commission will give guidance. And these are useful in the clarification that they give. So the first point, and the broad point that the Commission made, was that a third country broker-dealer may receive combined payments for research and execution as a single commission. Therefore, in principle, bundled or soft dollars are allowed. However, they can only do so as long as, one, they can identify the payment attributable to the research. Two, they can base the research budget on a reasonable assessment of the need for research. Three, they can subject the research budget to appropriate controls, which include maintaining a clear audit trail of payments made to the research providers. And fourth and finally, they're able at all times, and based on their own internal allocation process, to identify vis-a-vis their own clients the amount spent on research with a particular third country broker-dealer. So the need for very clear means of identification is one that comes through. And this, we say, that despite this more permissive regime, will still pose a requirement, possibly a challenge, both for the EU managers and indeed for their delegates. In response to a further question about whether a third country broker-dealer would be required to identify a separate charge for research in cases where a MiFID II manager or sub-advisor paid for these out of the RPA or indeed directly out of its own resources, the Commission firstly confirmed that a portfolio manager must ensure that they identify a separate charge for research. They must state, however, that in the absence of a separate research invoice, the MiFID II manager may decide, among other things, to consult with third parties with a view to determining the charge attributable to the research provided. And then thirdly and finally, confirm that the supply of and the charge for those benefits or services must not be influenced or conditioned by the levels of payment for execution. So very clear commitment really to the avoidance of inducements. So in short, the Commission frequently asked questions have been very useful in clarifying things with respect to research, but there may still be work both for the EU manager delegating and the US advisor taking on the sub-delegation to do. I think on that point it's probably useful to hand over to Holly at 5:30, just to talk a bit about the SEC no action letters that were published at the same time as the FAQ.
Andrew, thank you very much. And I will proceed to pick up where Andrew left off, but I wanted to first let everybody know who wants CLE credit for today's webcast, that the confirmation code is the word financial. So hopefully that's clear to everyone. Just enter financial to get the CLE credit. So as Andrew just explained, MiFID requires the unbundling of research from execution, but in the U.S., we have a long history of bundling research with trading. So a conflict was set up between MiFID II and the U.S. regulatory scheme that regulates U.S. broker-dealers and investment advisors. To give you some sense of how complicated this all became, if you look at the next slide, we tried to lay out the fundamentals of the U.S. regulatory regime that were impacted by the MiFID II decision to bring greater transparency to research payments. So in the U.S., we have Section 28E of the Securities Exchange Act of 1934. We have Section 17D of the Investment Company Act, Section 206 of the Investment Advisors Act, and Section 202A11 of the Investment Advisors Act. And I point that out because when the SEC here in the United States was discussing a solution to the research problem with its counterparts in Europe, the European parties were able to issue the FAQ along with their MiFID statutes to deal with it. But here in the United States, the SEC had to issue 3 no-action letters. So I really can't remember. I used to work for the SEC, but I honestly can't remember another time where it's taken 3 separate letters from the Securities and Exchange Commission to address a particular regulatory issue. So when you're trying to research this area and what's changed, you need to look for 3 letters that were issued on October 26th, just last week. And the links to those letters are in the PowerPoint for this presentation. So when you try to look at what's going on in the U.S. regulatory side, you have to realize that the reason we have, or maybe one of the primary reasons we have bundled research and trading and the cost for that in the United States is because if you go back in time along, I'm talking decades here, we had fixed commissions in the U.S. When the commission structure became unfixed, one of the vestiges of the commission structure system was that investment managers did not want to have to make a choice between trying to get the lowest price on a trade execution versus trying to get research that they valued in combination with those trade executions. So our U.S. Congress adopted Section 28E, it's in the Securities Exchange Act of 1934, to make it permissible for money managers to pay in combination for trading services and research in a bundled manner. Over the last 30 years or so, the SEC has issued a number of proposals and interpretive advice regarding how U.S. money managers and U.S. broker-dealers were to interpret Section 28E. And it's interesting, when I went back in the last few days and looked at some of that advice, when I went back to 2006, the SEC made a specific reference to its desire to cooperate with the regulators in the United Kingdom so that the market participants who were affected by both the UK regime and the US regime were not subjected to the costs of multiple regulatory regimes. I found that very interesting. I mean, in some ways, 10 years is not so long ago, but in some ways it really is because the markets evolve so fast. But that theme of U.S. cooperation with the EU regulators is very much evident in the 3 no-action letters that the SEC issued last week. To give you some sense of what those letters consist of, the first letter, these are not in any order of particular, I just need to get through all 3. One of the letters was issued by the SEC's Division of Trading and Markets to SIFMA, which, as you all know, is a very large trade organization here in the U.S. It was issued under Section 28E. Another letter was issued by a separate division of the SEC. The Division of Investment Management issued a second letter to SIFMA, and that is under Section 202A11 of the Investment Advisors Act of 1940. And then there's a third letter that was issued to the Investment Company Institute under the Investment Company Act of 1940. I will tell you that each letter needs to be carefully studied because although the letters were issued in tandem, very interestingly, they do not cite to each other, and each letter has its own terms and conditions and was issued to cover specific fact patterns. So, for instance, if you look at the letter that was issued under Section 28E, I think the takeaway from that letter is that U.S. broker-dealers may continue to receive payments for execution and research services under the Section 28E safe harbor, but there are a number of conditions that they must comply with, and maybe the most important for today's webinar is that the U.S. broker-dealer must be legally obligated by contract with a money manager to pay for research using a research payment account. A research payment account is an RPA. That's the new lingo we all have to get used to. That's what Andrew was referring to when he was speaking from the UK side. So an RPA will hold client assets that the client has consented to being used for research, and it must be under the control of the money manager. If there is excess money in that account that is not used for research for some reason, that money must be refunded to clients. So, as I said, there are many takeaways from the Section 28E letter, so I would urge you to look at that. The second letter that I will touch upon is the letter that was issued again to SIFMA and concerns whether U.S. broker-dealers would perhaps need to be registered as investment advisors here in the United States as a result of the changes in research payments brought forth by MiFID II. So SIFMA wrote to the SEC and said, please do not make U.S. broker-dealers register as investment advisors here in the United States. They are already heavily regulated by both the SEC and FINRA, and we don't think they should be subjected to another regulatory regime. The SEC agreed, but what's important to remember about this particular no-action letter is that it has a sunset date. It is effective only for 30 months, starting from MiFID II's implementation date. The SEC was very clear about saying that it may or may not renew the no-action position in that letter. It granted it for a temporary period only, and the reason for that is that the SEC wants to study the impact of MiFID II on the markets for research. That will be the global market for research, that will be the U.S. market for research, but they want to see what the changes in MiFID bring about in our U.S. capital markets and then have the ability to go back and speak on these issues again. The third letter, which is also equally important, and as I said, everyone needs to study all three letters, is that it was a no-action letter issued to the Investment Company Institute, and it will permit investment advisors to be able to continue the practice whereby they aggregate orders for a number of different clients. So as you all know, it is permissible here in the United States for investment advisors to aggregate orders from registered investment companies, employee benefit plans, individuals. They can put together very large orders on the theory that a large order can generally be executed at a lower price than many smaller orders. The SEC has permitted that practice for some time, as long as clients who participated in an order shared in the transaction costs on a pro rata basis. And of course, there were other conditions. What MiFID raised is the possibility that investment advisors would be violating SEC law when they executed aggregated orders, because within those orders, you could have clients that have multiple arrangements with respect to how they pay for research. So for example, you could have a registered investment company that was paying total transaction costs that include the cost of execution as well as research, but you could have other client orders in that aggregated order where those clients have different payment arrangements because of the MiFID II regulation. So that letter is extremely important in this space. As I said, investment advisors may continue after January to aggregate orders, but it's important to recognize that only investment advisors that are subject to MiFID II, either directly or contractually, can rely on that particular letter. I'm going to make some quick observations here before we move on to Meltem and Ray to talk about the way that MiFID II impacts derivatives. First, I just wanted to say that like all no-action letters issued by the SEC, they do have to be strictly complied with in order to rely on the relief. And in this case, the letters require that the U.S. component of the research arrangement comply with MiFID II. So in other words, it's not enough to look at the letters through the lens of the U.S. perspective only and complying with U.S. law. You must assure yourself that the arrangement itself complies with MiFID II. And in that respect, as Andrew mentioned, MiFID II imposes a number of operational challenges. There must be audit trail requirements, and there is a prohibition on research charges being influenced by levels of payment for execution services. So from a U.S. broker-dealer or money manager perspective, I think you definitely need a game plan for revisiting and revising existing contracts, internal policies and procedures, and most importantly, back-office operations. As we all know, back-office operations can sink the best policies and procedures. So I would tell everyone to pay attention to back-office as well as the legal issues. Second, I'll just raise briefly an issue that we don't know how this will play out, but it may be one of the reasons why the SEC has a temporary 30-month sunset on the issue of whether broker-dealers need to register as investment advisors. It might be that we are entering into sort of a dichotomy here where we have money managers who run global systems, also money managers who maybe just run U.S. systems, but the question arises whether internally those impacted by MiFID will run and develop within their offices two separate parallel systems, one designed to comply with MiFID and the U.S. regulations that apply to compliance with MiFID, and a separate U.S. system when MiFID doesn't apply, and whether we're going to see changes in research payment costs, trade execution costs, any changes that we could see from that duality. None of us knows the answer to that question yet, but I wanted to point it out because it is something that I think the SEC and others who are in this market will be paying attention to closely after January. With having said all of that, now we're going to enter into the world of derivatives with Ray Ramirez and Meltem Kodaman.
Thank you, Holly. My name is Ray Ramirez. I'm a regulatory and transactional derivatives attorney. And to give you a sense of what that really means, I joined the firm when Dodd-Frank passed, and I've often heard folks in the ERISA space refer to themselves as ERISA babies because they were around when ERISA passed. I like to call myself a Dodd-Frank baby. So I've basically grown up with Dodd-Frank, and my practice has been focused on helping our clients both negotiate the documentation they need to trade, but also ensure that they have the necessary compliance policies and procedures in place. And so a question that we often get is, okay, and before I get there, I should say most of our clients are end users of derivatives, so folks who are using derivatives for hedging purposes, and they're both financial and non-financial. So the perspective that we're bringing to this conversation is, okay, if you're a U.S. person who's using derivatives for hedging purposes, or primarily for hedging purposes, what is MiFID going to do to you? How does it impact you? And the answer up front is it's limited. The impact is not going to be as significant as you may think. A couple of things to note at the outset. The first is that a question we get is, well, does this actually apply to me? And the answer is, for the most part, it doesn't apply to you directly. What do I mean by that? What I mean by that is that MiFID II and MiFIR are directives and regulations that they're applicable to folks that are domiciled in the European Union. So the way that a U.S. person gets into or gets trapped up by MiFID II or MiFIR for purposes of derivatives transactions is if you're either trading on an EU venue or you're trading with an EU person. Otherwise, MiFID II and MiFIR don't apply to you. And further, many of the requirements, and folks who are familiar with EMIR will recognize the similarity, the requirements don't apply to you directly, meaning that what you're doing is taking steps to facilitate your counterparties' regulatory compliance obligations. And so in that regard, I think it's worth highlighting what Andrew mentioned earlier during the presentation, which is that although MiFID II and MiFIR may not apply to you directly, it may end up applying to you from a commercial perspective, because your counterparty will say, hey, if you want to continue to trade with me, you have to take the following steps. Otherwise, I'm not able to do so. So what we've done is we've identified the three general buckets in which that MiFID II will apply to a U.S. person. And the three buckets are transparency, position limits, and the trading obligation. And before I jump into the detail on each of those, I do want to flag that on the invites for this presentation, our colleague Alex Holton was supposed to be delivering part of this webinar. He is ill, and so Meltem Kodaman, my esteemed colleague, has volunteered to join. I should also say she volunteered to join about 2 hours before this presentation, so she is a rock star for that. The other thing is that Alex is one of the key point persons for position limits. So I'm going to fumble my way through, but to the extent that you have questions, you can feel free to reach out to Meltem, Alex, or I after the presentation. We're happy to give you more detail. So let's jump into transparency and what we mean by transparency. So one of the themes you probably picked up on during the course of the discussion so far is that one of the key things that MiFID II and MiFIR want to do is essentially cast light on the financial markets. Okay, and what that really means in the context of not just derivatives but generally is increased reporting, right? Now, the reporting requirements are primarily going to impact the EU person, so the EU trading venue on which you're trading futures, or your EU counterparty with which you're trading an over-the-counter transaction. So for the most part, U.S. persons are not going to have a reporting obligation. It's going to be borne by somebody else. With that said, there are two things that you should be aware of as a U.S. person. The first is your trade data is going to be reported to an EU regulator. So an EU regulator will see what your trading is. The second is your EU counterparties do need you to take certain steps to help them comply. The first is you need a legal entity identifier. Now, this is kind of old news for folks who are used to trading over-the-counter transactions because the European Market Infrastructure Regulation, which is parallel to Dodd-Frank in the U.S., required legal entity identifiers because reporting already kicked in. So for most people on the line, I suspect you have those legal entity identifiers, and this won't be a huge issue. But for some, you will need legal entity identifiers. The process is fairly straightforward. You go online and get one. The second is that your EU counterparties will likely need a confidentiality waiver from you. So EU confidentiality rules are very strict, and so even to report to a regulator, an EU person must get your permission. So in your trade documentation, which I know many of you likely already have by virtue of Dodd-Frank and EMIR, you will be asked to waive confidentiality rights. And that's pretty standard language at this point that appears in numerous ISDA documents. But so long as it's tied to the regulation, generally fine. The second big impact relates to position limits. And folks on the line may be familiar with the concept of position limits. It's essentially a cap on the size of a speculative position that you can take in a particular type of commodity instrument. So, for example, ag futures, right? In the U.S., we have position limits already. From a federal perspective, from regulatory perspective, we have limits on agricultural commodity transactions. Now, we also have exchange-set position limits, which are not set by the CFTC, the primary regulator, but are also binding to the extent that you're trading on a particular venue. Folks will be familiar, in the U.S., there have been efforts to impose federal position limits. They were actually passed several years ago and challenged, and they are still, they've been redrafted and remain with the regulator, but they're still not out yet. In the EU, they're going to go live on January 3rd. So it's possible that the EU, it's likely at this point that the EU is going to beat the U.S. on position limits. Now, the limits are going to apply in respect of physical commodity transactions. So what I mean by that are agricultural, energy, and metals transactions. And they're going to apply to exchange-traded transactions, i.e. futures, and they're also going to apply to economically equivalent over-the-counter transactions. So swaps that are economically equivalent to a futures. There will be two types of limits. There are the spot month limits, which are generally more onerous, and then other non-spot month limits as well. In terms of limits themselves, ESMA, which is the European Securities and Markets Authority, sets the calculation methodology for the establishment of position limits, but each of the member states has to actually submit their proposed limits to ESMA for approval. And they do have some discretion there, some flexibility. They can adjust for between 35% and 5% the limits for their jurisdiction. So far, a few jurisdictions have received approval of their position limits. So the UK really recently received approval. France has also received approval. What's interesting is that so far there are no energy commodity limits. They're limited to agricultural and metals. A few other points. There is a hedge exemption concept. It's a little distinct from the U.S. Hedge exemption concept, but there is one available. So if you're a non-financial counterparty and you're using a transaction to reduce risk relating to a commercial activity, then you are eligible for a hedge exemption, and you can actually go above the position limits. There's also aggregation at the head of the group level, and it's pretty much the rule is you have to aggregate. There is an exemption there for collective investment vehicles where you do not have to aggregate, but generally the rule is you must aggregate your positions among affiliated entities. What's important to note, and I think this is probably the biggest takeaway, is that the EU's limit regime generally does not have an extraterritorial effect. And what do I mean by that? What I mean by that is if you're not trading on an EU venue and you're not trading with an EU counterparty, then you're not subject to the limits. So you only become subject to the limits if you are on an EU venue or you're trading derivatives with an EU person. And I'll leave it at that and pass it on to my colleague Meltem to take us through the trading obligation.
Thanks, Ray. My name is Meltem Kodaman. I'm counsel in the derivatives office in our Washington office. Most of my clients are largely U.S. commercial end users of derivatives, many with affiliates overseas and or trading with non-U.S. entities. So these issues are relevant, as Ray highlighted early on. And I'm mindful of the fact we just have a few minutes left, so I'm going to try to move through these next few slides quickly. The third key change in respect of derivatives under MiFID II and MiFIR is the trading obligation. So essentially, you'll no longer be able to trade certain types of derivatives that have been identified by ESMA on a bilateral basis. Instead, you'll have to execute them on an electronic platform. So those of you who are familiar with the regulatory regime under Dodd-Frank, you'll recognize this as the trade execution mandate, where you have to trade certain swaps on a swap execution facility or a SEP. In the EU, there are three types of platforms. There's the organized trading facilities, or OTFs, multilateral trading facilities, or MTFs, and regulated markets, or RMs. And it's just what everybody needs, more acronyms to deal with, but those are what those are about. The initial list of swaps was published by ESMA last month, and it's still subject to European Parliament and Council's approval. It's expected that that approval, will happen. But in any case, it is essentially the same as the U.S.'s list. Plain vanilla interest rate swaps and index-based credit default swaps. Those that are familiar with the U.S. regime will note that the process by which swaps will be designated as subject to the trading obligation is distinct. In the U.S., it starts with trading platforms themselves, whereas in the EU, it will be up to the regulator ESMA. It's also worth noting that in the U.S., like in the U.S., only those swaps that are subject to mandatory clearing can be subject to the trading obligation, which means that you'll have a fair amount of notice, advance notice as to covered products, and further, the requirement will be limited to liquid and standardized type transactions. In terms of who the trading obligation applies to, EU-domiciled financial counterparties, referred to as FCs, and non-financial counterparties that exceed certain specified clearing thresholds, referred to as NFC pluses, they are subject to the requirement. For U.S. persons, the requirement will apply whether you engage in a trade, whenever you engage in a trade, I should say, that is subject to the trading obligation with such a person, and you yourself would be classified as an FC or an NFC if you were in the EU. So in other words, you're engaging in the same determination of your classification as you would have under EMIR. U.S. persons that have, quote, a direct and foreseeable effect in the EU may also get caught up in this, but based on guidance on that particular category, it's unlikely that, our U.S. clients would be subject to that. There are certain exceptions from the requirement overall, but they're pretty narrow. Certain inter-affiliate transactions will be exempt from this requirement, as will certain pension scheme arrangements. The trading obligation raises a key problem in the cross-border context. As with clearing, a trade can really only be executed once. So how does this work when you have two regimes that require you to engage in this trade execution on a platform? So this raises a question of equivalence, whether the U.S. will recognize execution on an EU venue as compliance and vice versa. We have good news on that front. The U.S. and the EU have announced, one of their path forwards. This is where they agree in principle that there will be equivalence on a particular regulation. And since it's so similar here, it certainly makes sense. The devil will be in the details on this path forward, but practically what it means is that the trading obligation requirement should not be a significant disruption for U.S. persons who are trading with EU persons. That said, the actual equivalence determinations are due out this month, and it'll be interesting to see how some of the key issues that we're thinking about will be handled. For example, package transactions. In the U.S., some types of package transactions benefit from CFTC no-action relief. This is important because having a trade on a CEF would run counter to the economics of a package. Now, ESMA doesn't have the authority to grant similar relief. It's up to the individual member states. So it's going to be interesting to see how that is handled on an equivalence basis. Another issue that we've identified is reporting. One of the keys here is reporting by the relevant venue to the regulator. So if you trade on an EU venue, will the EU venue have to report to a U.S. swap data repository, or can it report to an EU repository? And if the latter, how will that information eventually make its way over to the U.S.? We don't really have answers to these questions, but hopefully they'll be set forth in the equivalence determination. We also wanted to add just a quick few additional points on FX forwards and how they would be treated under MiFID II. So as you're likely aware, FX forwards are largely outside the scope of Dodd-Frank regulations in the U.S. In the EU, however, they will be classified as financial instruments. Currently, they've been exempt in the EU from regulation, but that exemption ends on January 3rd when MiFID II takes effect. Notably, this means that FX forwards will be subject to the variation margin requirements on or after January 3rd. FX forwards are not subject to the requirements in the U.S., so this is a potentially significant issue for our U.S. clients who are entering into such transactions with EU FCs or NFC plus entities. Certain exemptions will apply after January 3rd, notably those FX forwards that are entered into in connection with payment transactions. So these are generally deals where the FX forward is an ancillary piece to a greater transaction where payment is being made. But note, however, that while this looks like a good thing, and it is, it's actually, there used to be a more broad exemption called a commercial use exemption. So this payment transaction exemption is actually a narrowing of what folks were used to before. We're kind of running out of time, so I don't know, Ray, I know you got one slide.
Yeah, I'll and just to reiterate, the three big buckets are the ones we flagged already, which are transparency, position limits, and the trade obligation. We're now kind of in the world of et cetera, which are not so little et cetera for folks, but not within kind of the bigger buckets. In terms of platform trading, which is the last slide here, I'll be quick. Direct electronic access. So this talks about where an end user is accessing a venue's order book by using a member's trading code. And the takeaway here is that once MiFID II enters into force, only a MiFID regulated investment firm or a TCE, a third country entity that's deemed equivalent to MiFID by the European Commission, is supposed to provide direct electronic access. And clients must also be MiFID regulated or, again, deemed equivalent by the European Commission. So that's one issue that we have there. And the question that it raises is, can someone from the U.S. really offer direct electronic access to one of these trading venues? There have been questions about, the time taken to reach a trading venue and whether that influences whether an order can be considered direct electronic access or not. And ESMA has come out and said, no, that doesn't. But one item to note, there are also requirements related to algorithmic trading and high-frequency trading. I'll note that high-frequency trading is considered a subset of algorithmic trading. On the algo trading side, algo traders are required to have systems and risk controls in place to ensure that they have capacity and as well as thresholds and limits. And then in high-frequency trading, there's a record-keeping requirement to be aware of. And I apologize for rushing through that, but I'm going to
I think we're all fine. We're all fine and good here. Is my viewpoint. We wanted to thank everyone for joining us today. We appreciate your time. If you would like to receive CLE credit, as I said before, just download the CLE sign-in sheet and enter the word financial. We did receive a number of questions during the course of the webinar, and because of the material we had to cover, we couldn't get to the questions. But one of the five of us, will be reaching out to anyone who asked a question and following up with you individually. And as I mentioned also, if anyone would like a copy of the PowerPoint, just send us an email and we'll take care of that quickly. Again, thank you very much. Bye-bye.
Bye-bye.